replacement for that paragraph on page 14. And the bottom paragraph starts while committing or attempting to commit. Are you all in that spot? I have given you a replacement for that paragraph, and that separate sheet was found on your seats as you came in. I'm going to read that out loud to you. It says, while committing or attempting to commit, or while fleeing immediately after committing or attempting to commit means that the death must occur as part of acts leading up to or occurring during or immediately after the commission of kidnapping or aggravated burglary or trespass in a habitation when a person is present or likely to be present, and that the death was directly associated with the commission or flight immediately after the commission of kidnapping or aggravated burglary or trespass in a habitation when a person is present or likely to be present. So if you've got a pen or something, you can scratch out that previous paragraph at the bottom of page 14, top of 15, and use this paragraph in that spot. I'll give you a moment to do that. Counsel satisfied with the instructions?
Yes, Your Honor.
Yes. Right. You're satisfied with the instructions?
Yes.
Well, at this point, we're going to go to the closing argument of the attorneys. Mr. Mulligan will, the state goes first, the defense follows, and then the state has the last word. Mr. Mulligan?
Thank you, Your Honor, and thank you, ladies and gentlemen of the jury. It's my opportunity to present an argument to you about why I believe the state has proved its case beyond a reasonable doubt with regard to all of the elements of these 7 offenses that are contained in the indictment in this case. You will have available to you all of the exhibits that have been admitted in this case. The exhibits that are here, the box with the gun. I think maybe the judge may hold the live rounds out of the jury's possession. If you need them, I think they'll be available, but otherwise I think they're not going to give you a gun and bullets at the same time. No offense. Also, you'll have the pictures, the 911 call, and then although the bag isn't out here right now, that'll be available to you as well. I'm sure that our court reporter will get it into you for your deliberation, should you care to see that. So you're welcome to look through these things and to peruse them to assist in your deliberations. One of the exhibits you'll have is State's Exhibit 50. I'll put up the front page of that. This has been admitted into evidence, and it is the text messages between Amy and Randy. And they start up there on, let's see, they start on February 14th, and I think the last one is on the date of Amy's murder, March 27th. We have highlighted them for your assistance. The blue ones are the communications that Randy sent to Amy, and the pink ones are the communications that Amy sent to Randy. So you'll be able to, there's a number of pages, you can again go through them to your heart's content. I will use some of those pages in my argument to you, my closing argument, and those pages that I'm using have been tabbed. So if you care to go back through and see the references that I made in my argument, those are tabbed. Okay, the first count, aggravated murder, requires a number of elements. And some of those elements are common to all of the offenses. They happen in Ottawa County. There's really no dispute about that. The elements happened, or the offenses happened all on the same day, March 27th. There's been no dispute about that. To identify the defendant, we have to identify the defendant as the perpetrator of these crimes. That was no big stretch here because Randy Ross is known to his sister-in-law, he's known to his niece, and he was even known to Jody Hatfield, Chief of Police of Carroll Township, who arrived first on the scene in response to the 911 call. So there's really no question about the identity of the defendant either. That leaves us with just a couple other elements in the first offense to discuss, and that would be that it was his purpose to cause Amy's death. Now, he walked up to that house on Lights Road after driving there. He walked from the driveway to the house. And he walked up to the house with this .40 caliber Ruger. I'm going to show this firearm to Detective Harrell, and she can make sure it's safe. Pardon? Okay, thank you. He walked up to the house. No communication at all with the people inside the house, but he's going in with this gun, this firearm. There is into that house with this .40 caliber gun, but he couldn't just walk in. He had to get into the house. This door was locked. That's the force that was needed for him to get into that house with this gun. Is this gun for protection? Is there a big burly guy inside that house? You saw how big Andrea is. You saw how big Summer is 3 years after the incident. She's 16 now. She was 13 then. And you have seen the pictures of Amy's body. These are all petite people. He did not need this gun for protection. This was an offensive weapon. He was going to use it to take somebody's life. That was his purpose. That's why he walked into that house, banged that door down, busted that door in, chased all of those small women up those stairs, pointed this gun directly at Amy, and said, "You think you can take my things?" Boom! Right through her heart. One shot, and she was dead. Right through the heart. That is a purpose, to take her life. What else do we know about the purpose to take her life? He pulled her down by her hair and held it to her head. She got away, and that's when, within 4 foot of Andrea, he shot her sister dead. Now, for that first count, we also have to show you prior calculation and design. Let's talk about what Randy Ross was doing that morning. Okay, he left Pemberville, according to Gail Lowrich, at 10:15. left work at 10:15. And Gail said he was going to go home and change, talked about dinner and a movie and so forth, and upbeat, and went to his home outside of Fremont. That's Pemberville, that's Fremont. This is Lights Road where the murder occurred. Okay? So, 10:15, goes to Fremont Road, and then from Fremont Road, we see him coming into Oak Harbor at a high rate of speed. So fast that Peter Klaus sees him coming in over the Route 19 bridge over the Portage River, and he's going so fast that his car lofts up and down as it hits that little incline to hit the bridge. Peter waves to him, and they always exchange that pleasantry as they go by, but there was no pleasantry from the defendant that day. Fast and focused. Peter said by the time he left Fremont, he was on his way to Fremont from Oak Harbor, but before he left Fremont, he had received from a friend notice that Randy had killed his wife. Peter also said something very interesting, and something that you'll get a flavor for in State's Exhibit 150, these texts. That a friend of his cousins worked at Waldo Pepper's restaurant bar, and Randy's bugging him, is my wife in there? Is she with guys? I need to know. Called him a couple times about that. That's his attitude about his wife. So, Pemberville, Fremont to Lights Road. Well, what do we know about when he arrived at Lights Road? Summer. Let me get the TVs on. Summer was texting. She said in her own testimony, real time. She is texting real time what's going on. And, Joe, do you want to focus in on for me? On the 27th, which is right in the middle. Right there, right there. Okay, if you look at 3/27/13, 3:43:21 p.m., Randy is here. A couple things about that entry. We know it's on March 27th, Amy's last day on this earth. And we know that the time is 4 hours off. Instead of 3:43, that's 11:43. And that's from Detective Morford's testimony. Okay? We also know from the 911 tape that we're just shortly before noon on the 27th. Randy is here. Okay, at 3:44, Summer has asked, who is Randy? And Summer said, Amy's husband, he's knocking, we are in my room. That's 3:44. Her friend Kennedy texts her back a little emoticon, and then at 3:46:48, which would be 11:46 in local time, he's shot. So from being here 3:44 to he shot 3:46, 2 minutes. 2 minutes. Okay, so what time does he arrive there, did I say? Randy is here 3:43. 3:43 is there, 3:44 he's knocking, 3:46 Amy's dead. Okay, that translates to 11:43. We know from Agent Ryder's testimony, that this trip takes 65 minutes. Each leg is roughly the same. We'll call these 30, 35-minute legs, if you will. So 10:15, he leaves Pemberville and he arrives in Fremont approximately 10:45. What does he see at 10:45 when he gets home? Furniture's gone. Okay. Now, we can move out of our home. We can move out and take an overnight bag, and who's going to notice? I mean, maybe some of your underwear is missing from your dresser drawer, maybe a pair of jeans are missing from your closet, but really, what do you notice when you walk in the house? Everything looks the same. Everything is the same. But when you walk into a home and the furniture's gone from your closet, but really, what do you notice when you walk in the house? Everything looks the same. Everything is the same. But when you walk into a home and the furniture's gone, when you walk in that door, it must have hit him like a ton of bricks. She meant it. She's gone. She's not here. Furniture's gone. She's been living with her sister for a while, living out of a suitcase. I had hope. I had hope when I left Pemberville this morning that we were going to reconcile. That's what I told Gail. That hope is fading when he gets home and walks through that door. It's fading real fast. State's Exhibit 50, I'm going to remove the very last page for a second.
Joe, check the box up. It's all red.
This, while Joe's getting it up, I'll show it to you as soon as he gets it up. This is a text. It is the last text
There it is.
that Amy Ross sent in her life. This is the last thing that she sent. And again, this is from her to Randy. I'm still really sick, can't talk, can't meet today. 3/27/13, 2:53. Back that up 4 hours. 2:53 becomes 11:53. I'm sorry, 10:53. So at 10:53, he pretty much has to abandon hope of reconciliation at that point, because at 10:53, he's seen that his furniture is all gone, the house is forever changed, and she doesn't want to meet with him. Her calculation and design. If he's going to reconcile, does he pick up a box of chocolates or a bouquet of flowers to take to see Amy? No. He takes that gun. That's what Randy Ross decides to take to a reconciliation meeting, a gun. That's no reconciliation, that's prior calculation and design. He drives then from Fremont to Lights Road. 35-minute drive, he's got plenty of time to get there from 10:45, 10:53 to 11:43 when he's seen at the house. He has all that time to think about what he's going to do. All that time to plan. All that time to decide he won't be denied what he wants to do. That door will not deny him entry into that home. He wants to get in to do what he wants to do. And what does he want to do? He wants to kill Amy. And he wants to get in one last dig, the last thing that Amy probably ever heard in her whole life. Is, you think you can take everything from me? Boom! I'll take every ounce of life from your young body before you take everything from me. It's exactly what he did. He didn't walk up to that house. He didn't park in the driveway, leave his truck with the flowers in hand or a box of chocolates, drop the flowers and chocolates when he couldn't get back in and go get a gun. No. He walked out of that truck with guns and bullets up to that door. Is suicide something that any of us imagine is taken lightly? Is suicide something that you think about? Is suicide something that is a profound, defining definition, defining moment in your life? Do you think that he decided that on the spur of the moment? Boom, I shoot Amy, and then boom, boom, I shoot myself trying to commit suicide? Prior calculation and design. All of that is prior calculation and design. Okay, ladies and gentlemen, that's the first count. Let's look at the second count. So with the first count, we have identifying the defendant in Ottawa County, all of those things that are applicable to all the other counts, purposely caused Amy's death, prior calculation and design. The second count is just like that. Instead of prior calculation and design, it's to purposely cause her death while committing an offense, a serious offense: kidnapping, aggravated burglary, or simply trespassing in somebody's house when they're there. That is all we need to show. That he purposely took Amy's life while he was trespassing in that house and other people were there. There's no question that Amy and Andrea and Summer were in that house, so we have the other people in that house. Was he trespassing? He was told he couldn't go there. He was told not to come. He was presented with two locked doors, one in the back and one in the front. He never got to the back door, but this front door did not provide enough security against Randy Ross. This front door gave way to his force. Is that trespassing when somebody tells you not to come in their house and you bust the door in? You're darn right it is. So there's the second count of aggravated murder. Now the judge has told you in the instructions, and by the way, if my argument to you differs from the judge's instructions, by all means you go by the judge's instructions. I need my argument to comply with the judge's instructions. But his instructions on multiple counts are, you are to consider every count separately. So if you come to a verdict of guilty on count 1 with respect to aggravated murder, you go on to another count and you decide that count without regard for your verdict on count 1, and so on and so forth. Okay? So every count is determined on its own merits. So I would submit to you that we have trespassing in the Lights Road home. And let me show you how Randy knows that he was not to be in that home. As I said, I have a certain pages tab on State's Exhibit 150. And you will find on March 6th, a little bit more, there you go, a text from Amy. And the reason this is captioned aggravated burglary, or trespass in a habitation when a person is present is because I think these go to all of those offenses. Amy texts to Randy, March 6th, 21 days before he kills her. If you come near me, here or anywhere else, I will press charges. I have never been more serious. Stay away, you're not welcome, you'll be a trespasser. March 7th, the next day. If you come near me, I will have you arrested. The time is the time from State's Exhibit 150. So the real time and local time, you'd have to back that off 4 hours. But otherwise, they're directly from here, from State's 150. Don't come near me even. Stay away. March 14th. Randy texts to Amy, I'm on my way. Amy, back to him. No, you are not. I told you not to come here. You'll be a trespasser. Stay away. March 17th. Again, Amy to Randy, don't come here. I'm very serious. And 4 days before she was murdered. If you come to Andy's house, I will have you arrested. You are not welcome. You're a trespasser. If you force your way in here, you're a burglar. Ladies and gentlemen, there is your other element for the second count of aggravated murder. third count of the indictment is murder. And murder is to purposely cause the death of Amy Ross. I went over that with my argument for aggravated murder in the first count. I won't bore you with being redundant. Count 4, murder. Again, to cause the death of Amy Ross. Not to purposely cause her death, but just to cause her death, while committing an offense of violence. In other words, as your instructions say, aggravated burglary, kidnapping, and 2 counts of burglary. Okay? That's what he was doing, okay? He was a burglar in that house. He committed aggravated burglary in that house. There's your 4th count, murder. Fifth count, aggravated burglary. By force, stealth, or deception, trespass in an occupied structure when another person is present, other than an accomplice, he had no accomplice, with purpose to commit in the structure a criminal offense and you inflict physical harm on another. What was his criminal offense? He wanted to kill his wife. His criminal offense is the same thing that shows you that he wanted to inflict physical harm on a person. Killing somebody is physical harm. Serious physical harm. Ladies and gentlemen, that is the force that Randy Ross had to apply to this door to gain entrance into that house. Can you imagine the ladies in that house while this was happening?
Yes.
I would draw that, Your Honor.
Thank you.
Excuse me, Your Honor. Aggravated burglary, count 5. Aggravated burglary, count 6. Trespass in an occupied structure, commit a criminal offense while having a deadly weapon on your person. We know it's deadly because he killed Amy with it. It's the gun. Now, talk just a second more about the gun. The firearm. There's a firearm specification on each count of the indictment. We know this is a firearm. We know it's capable of expelling a projectile with an explosive force because it killed Amy Ross. This gun killed Amy Ross. We know that it has been fired 3 more times, at least 3 times since it killed Amy Ross. It shot Randy Ross twice in the head, and then Agent White shot it as well and found the gun to be operable. So we know this is a firearm. We know it works. I mean, it seems a little ridiculous. We all can see this is a gun, but we've got to show you that it works, okay? So there's your firearm specification with regard to all of the offenses. In regard to count 6 of the indictment. We're going to send some gloves back into the jury room with you in case you want to handle that yourselves. Okay, kidnapping, the last count of the indictment. By force, restrain somebody of their liberty, restrain a person of their liberty to terrorize or inflict serious physical harm. Randy Ross has that gun. They first see that gun as they are walking upstairs. He's pulling the gun. He's holding the gun. Andrea saw it at approximately the same time. She heard Amy say, "He's got a gun." They ran up the stairs, went into this room, and tried to hold the door from him. But they just couldn't do it. They're two small women. Again, he didn't need that gun for protection. He got into this room, he held Amy by her hair, restraining her of her liberty, and put the gun to her head, terrorizing her. If you remember the testimony of Andrea, Andrea motioned with her hands around her head, indicating that Amy was trying to get Randy's hands off of her hair to let her go. He is restraining her of her liberty, won't let her go, and where she somehow struggles free, we don't know. Maybe he let her go, maybe she struggled free on her own, because the witnesses did not see that. They were in this closet. They saw him standing there. Amy is over here. You think anybody wanted to be in that room when he was holding a gun on him? No, but that gun kept them there. And this door is closed. Closed behind Randy Ross. So the only way for them to get out of there is to walk by Randy Ross with a gun and to have to open that door and go through it. This door is closed. And how do we know the door is closed? Because he shoots himself twice there. And we have blood splatter on this side of the door and none on the edge of the door. So that door is closed when he shoots Amy, when he restrains her of her liberty, when he terrorizes her, when he inflicts serious physical harm on her. If you look at your jury instructions, you will see that the restraint need not be for any specific period of time, just like prior calculation and design. Prior calculation and design does not need to be for a specific length of time. It doesn't need to be for 2 minutes. It doesn't need to be from 10:53 to 11:43. You just have to be able to formulate your prior calculation and design. Kidnapping been a problem before for them? Well, look at this. 20 days before Randy Ross killed Amy, she texts him, "I could have you arrested for assault and kidnapping." It's right in there under the tab.
Objection.
You want to come forward, please? On, correct. Okay. Stretch, talk.
Two other things. The judge has read you a number of times the definition of proof beyond a reasonable doubt. Just remember that it's not proof beyond any doubt, proof beyond a shadow of a doubt. It's proof beyond a reasonable doubt. It's what we use in courtrooms every day throughout the state of Ohio, throughout the United States. It's the same proof we use for a speeding case, the same proof we're using for this case. And I will leave you where we started with a discussion of prior calculation and design. Randy to Amy, I've asked God to forgive me for what I'm about to do. March 12th. Randy to Amy, I'm thinking you want this to get ugly. March 18th. Randy to Amy, true forgiveness is the answer, or we will both burn in hell. Randy to Amy, March 19th.
Same objection?
Yes.
Response?
There's no act at all here, just words.
I'm going to find that this is argument, it's not new evidence. You may continue.
Randy to Amy, I do not want to burn in hell for this, and we both will. Amy to Randy, burn in hell. Randy, with you, slut, 3 days before she's murdered. And then, literally the nail, figuratively, the nail in Amy's coffin. She says, I'm stiff, we can't meet today. Abandon hope of getting together. Thank you, ladies and gentlemen. That's all I have.
Thank you, Mr. Mullen. Mr. Beck?
Thank you, Judge. Ladies and gentlemen of the jury, good afternoon. I would like to thank you on behalf of Mr. Ross, Spiros Kokovis, and myself for serving on this jury. It's been often said that only higher calling to our republic is that of military service. On Monday, as jurors, you took an oath that you will follow the law. The law has been given to you in the form of jury instructions. And in those jury instructions, you have some time-honored traditions, constitutional cornerstones, presumption of innocence, that Mr. Ross, as he sits before you, is presumed innocent, and that cloak of innocence will remain upon him until the state of Ohio has proven each and every element beyond a reasonable doubt. And that the state of Ohio has the burden of proof in this case, that they must prove each and every element beyond a reasonable doubt. And if they do not prove each and every element beyond a reasonable doubt, you must find Mr. Ross not guilty of that charge. Now, in the present case, we feel that the state of Ohio has not proven each and every essential element beyond a reasonable doubt. One, that Randall Ross did not commit an aggravated burglary, another aggravated burglary, a kidnapping, and no aggravated murders. And what we have here is a lack of intent. As Mr. Kukovis talked about in his opening statement to you, on March 27, 2013, Randall Ross's world was collapsing around him. All of his walls collapsed, his foundation, his columns, whatever you want to call it. It was coming down. And one of the things that you need to do, and Mr. Mulligan pointed out in his opening, these text messages. Now, ladies and gentlemen, you're going to have a lot of text messages. You're going to have lots of them. Go through them, look at them. They show you just a little bit. They don't show you things from the other side. They don't show the toxicity of a relationship. They don't show you that Randall Ross wanted to get back with his wife. She's everything to him. I want you back. Over and over and over again. That's all he talks about. Are there other things? There's things both ways, ladies and gentlemen. Calling Mr. Ross names, saying things to Mr. Ross. What Randall Ross intended to do on March 27, 2013 was save his marriage. He felt that his world was collapsing. It was coming down quick. And what happened? He snapped. He snapped. That's what it comes down to. When you look at the background and the dynamics of this relationship, through testimony yesterday, through the text messages, through all of the evidence that you'll have. The parties were together for 17 years. It was testified to some brief bit yesterday, but it's also in the text messages. And it's a referral by Amy. They had a beautiful home together, a home that you will see a picture of, that they took a picture of last week, something that they refer to. And there's talk in these text messages about this home, setting a fire, looking for mushrooms, running across the yard looking for mushrooms. Cozy, quiet, away from everything. A home that both parties had a lot invested in, financially especially. Because within those text messages, you're going to see a lot of things, a lot of reference to selling the house, making sure that the bills are paid, making sure that the house doesn't fall into foreclosure, making sure that it's not repossessed. You look at the first text, I love you, dated February 27th. And this is right around the time that Amy Ross moved out for the last time. Now remember, yesterday there was testimony also that Amy Ross had moved out. I believe this was the 5th time, and 4 times had gone back. And this is throughout the 17-year relationship. Throughout this month of text messages, and you'll have numerous pages of text messages, he tells her he loves her, he wants to make things work, he talks about the past, small things that they did, hunting for mushrooms, having a cozy fire. He can help take care of her. She has some health issues. I can help you out. Offers to purchase things for her. And one of them offers to purchase a Jeep. But also, within those text messages, and when you look at them, he accepts his mistakes. He accepts his shortcomings. There's also a lot of talk over things that Randy did. that Randy is made guilty for. There's talk of Randy going to a church. It's referred to as a psycho church. That's what she calls it in the text. There's talk of forgiveness all throughout those texts. Now the state will present it to you in their light most favorable, but when you read all the texts, you will see the relationship, the badgering back and forth, and it's from her too, and from him. You'll see a lot of things said, because a lot of times people step back and go, I shouldn't have said that. I shouldn't have done this. We do that in human nature. He does seek for forgiveness for his past acts. You'll read about it in the text messages. But most importantly, what he wants to do is rekindle his love, get his marriage back. Everything was collapsing around him. When he went to that house that day, he did not have the intent to commit a crime. He wanted to get his wife back. Now, throughout this month, the state's leading you to believe that the boiling point came on March 27th when Randy went home, and all of a sudden, furniture was gone, things were gone. When you read the messages and go through the evidence, what you will see is the fact that the parties had actually entered into settlement. There were offers here, there were offers there. There was things in regards to almost a whole property settlement. There aren't any children, so what you're talking about is money or goods. And they're actually talking about it, throwing numbers at each other. There's talk over how much a lawyer costs. There's talk how much I'm going to pay you. Who's going to take care of the debt? And yes, they talk about selling the house. And also, there's a lot of talk about dogs in there. You'll read about them. Now, Randy, he wants to get a dissolution because it's less expensive. So what happened that day? If the state thinks that that's the boiling point, the tip-over point, and all because of that, he went there to commit a crime, he didn't. When you read the text messages, you'll see it. When Randy Ross went to that home, he did not have specific intent. Now today, you heard probably about 73 pages, I think it is, 73 pages, 74 pages of jury instructions. And a lot of times you're going to have in those instructions certain phrases. Specific intent. You're going to see that in every charge alleged. Did he have the specific intent? We argue no. Because look at that day. We have testimony from his boss, Gail Lobich, who works at the city of Pemberville, who says he was Randy's supervisor and Randy had worked there for 3 months at the water plant. He told you how on Monday, which is the death of Miss Ross happens on a Wednesday. On Monday he tells his boss, I'm going to have a meeting with my wife on Wednesday. I think we're going to get back together. He tells him on Wednesday, I'm leaving work early. He's a good employee. I want to go home, then get changed, take her to lunch and a movie. I think I'm getting back with her. And like I said, the state wants you to think that he went home and it's a boiling point. It's a tip-over. It's not. Really, what happened is he wanted to save his marriage. Because when he left the house, left work that day on the 27th of March 2013, described by a person who's not related to Randy, who's his boss for only 3 months, says he left quite happy. Is that the type of man who is going with a specific intent to kill his estranged wife and then try to kill himself? No, it's not. Not at all. Now in count 1, the state has the allegation of prior calculation and design. I'm sorry. It's set forth for you in page 7 of your jury instructions. And it says, prior calculation and design means that the purpose to cause the death was reached by a definite process of reasoning in advance of the homicide, which process of reasoning must have included a mental plan involving the studied consideration of the method and the means or instrument with which to cause the death. To constitute prior calculation, there must have been sufficient time and opportunity for the planning of an act of homicide, and the circumstances surrounding the homicide must show a scheme designed to carry out the calculated design to cause the death. No definite period of time must elapse. No particular amount of consideration must be given, but acting on the spur of the moment or after momentary consideration of the purpose to cause the death is not sufficient. That's what happened here on March 27, 2013. What we have here is a spur of the decision, a spur of the moment decision. His life is collapsing. Everything around him is going down. Remember, as an element, prior calculation and design to count 1 is not present. So for that reason, and for the reason that there's no specific intent, we ask that you find Randall Ross not guilty of aggravated murder in count 1. The presumption of innocence is not overcome, and the proper and just verdict following your oath is not guilty. Now, as to count 2, which is aggravated murder in the commission of an aggravated burglary, a burglary, trespass in an occupied structure, and or kidnapping, we ask that you look at all the facts and circumstances and evidence. He did not go there with the specific intent to cause the death of Amy Ross. And remember, throughout your jury instructions, you will have specific intent. Result: a person acts purposely when it is his specific intention to cause a certain result. It must be established in this case that at the time in question, there was present in the mind of the defendant a specific intention to purposely cause the death of another. That is not present for the aggravated burglary. That is not present for a burglary. That is not present for trespass in an occupied structure when another is present. And it's not present for the kidnapping. Because specific intent, this did not happen with prior calculation and design. It was a spur-of-the-moment offense. It did not happen during the commission of a kidnapping because it comes down again to specific intent. The specific intent is not there. Now, in this case, there's not a lot of things that are in dispute. One, it is not in dispute that Amy Ross is deceased. And really, it's not in dispute that Randall Ross caused the death of Amy Ross. Because what happens, ladies and gentlemen, you have 7 charges. Charges 3 and 4. Murder. Count 3, defendant is charged with murder. Before you can find the defendant guilty of murder, you must find beyond a reasonable doubt that on or about the 27th day of March 2013 in Ottawa County, Ohio, defendant purposely caused the death of Amy Ross. And then it goes through all of the instructions and all of the elements. You have a specification also. You also have an alternative, what's been common of murder. Defendant is charged with murder. Before you can find the defendant guilty of murder, you must find beyond a reasonable doubt that on or about the 27th day of March 2013, and in Ottawa County, Ohio, the defendant caused the death of Amy Ross as a proximate result of committing or attempting to commit an offense of violence, that is count 5, aggravated burglary, count 6, aggravated burglary, count 7, kidnapping or burglary of one of two, revised code section 2911, 12A1 or A2. Those are the proper charges in this case. This did not happen with prior calculation and design. It was a spur-of-the-moment offense. It did not happen during the commission of a kidnapping because Mr. Ross did not go there with the specific intent to kidnap the person. At the time, the specific intent not to cause the death of Mrs. Ross. Also, he did not go there with the specific intent to commit an aggravated burglary or burglary. It was a spur of the moment. Randall Ross snapped that day. His world was collapsing around him. He went there as a last-ditch effort to save his marriage. He just snapped. In your charge, counts 3, count 4 are murder. The extra additional elements which need to be proven beyond a reasonable doubt for aggravated murder are not present. Most specifically, specific intent. He did not go there with the intent to commit an aggravated burglary, a kidnapping, or a trespass. Really, Randy thought he could reconcile throughout it all, especially when you read those texts. You'll see texts amongst each other. You'll see some vile texts. You'll see some toxic texts. But what you'll also see is a hope that Randy can reconcile with his wife. That is why he went there. He did not go there to commit a crime. The intent is not present to sustain a conviction of aggravated burglary. It's not there to sustain a conviction of the other aggravated burglary. It's not there to sustain a conviction of kidnapping. It's not there. There's no prior calculation and design. Randy snapped. Because this was not done with the specific intent, and it's right on your jury instructions, page 17, a person acts purposely when it is specific intention to cause a certain result. It must be established in this case that at the time in question there was present in the mind of the defendant a specific intention to purposely cause the death of another. That's not there for the aggravated murder. There's no prior calculation and design. Ladies and gentlemen, the evidence put before you is that of murder, not aggravated murder, not aggravated burglary, not kidnapping. We ask you to follow your oath and find him guilty of murder with the firearm specification. That has been proven. The other charges have not been proven, and that is what we ask for, and we feel the evidence has shown. Thank you.
Thank you, Mr. Denman.
Thank you, Your Honor. Ladies and gentlemen of the jury, well, it appears as though murder is not an issue to the defense. The arguments they raise have to do with aggravated murder, and they focus on prior calculation design and specific intention. I think what's important to consider when you are reviewing the jury instructions is the definitions. So you look at what does the defense mean by specific intent. And that is in the result subsection when you're looking at those counts in the instructions. But specific intention is not the same thing as prior calculation and design, right? They're different. Specific intention really means What did Mr. Ross intend to do when he was doing what he did? What did he mean to do when he broke down this door on the 27th? His intention was to break down the door to get to Amy Ross, right? And that fell in line with his prior calculation and design, which goes to the aggravated murder. And that was he wanted to kill Amy Ross. And then you can get into the other evidence, the text messages, as well as all the other evidence you heard at trial. And Mr. Mulligan pointed that out very well during his closing argument. For example, the time that Mr. Ross left work, the hour it took him to get to Amy's house, that was all time to think about what he was doing. He went to his house, probably got his gun at his house. So
Objection, Your Honor.
I'll withdraw.
I'll
withdraw it, Your Honor. He went to his house. Took him an hour to get there to Amy's house. He got there, broke down the door, and we all know what he did. Okay. Specific intention is not the same thing as prior calculation and design. What was Mr. Ross doing when he broke down the door? What was Mr. Ross doing during the kidnapping? The kidnapping has to do with Mr. Ross grabbing Amy Ross's hair, right, and holding her against her liberty. You also have evidence that during the attack, Mr. Ross had at some point shut the door, and he had a gun. His intention was to restrain Amy Ross's liberty. That was his specific intention. Now, whether he spent a lot of time thinking about exactly what he was going to do the moment he got there, if he was going to grab Amy's hair, he spent a lot of time thinking about that. If he was going to actually have to break down the door, if he knew somehow that the door was going to be locked when he got there, and he knew that for days beforehand. No, we don't know that. There's no way to know that, and there's no way we really could know that. But we know that when he did these things, he intended to break down the door. He intended to restrain Amy's liberty. And he did this with the prior calculation designed to kill her. He had a lot of time to think about this. During Mr. Mulligan's closing argument, there were text messages that... The ones he pulled out. Thanks. Prior calculation design. So this is not the same thing as specific intent. This requires more, but there is no duration that's in your instructions. But we do have some evidence that he thought about this for a significant period of time. Prior calculation. Randy, I do not want to burn in hell for this, and we both will. That was on March 19th. Amy Ross was killed on March 27th. This is 8 days before Randy killed her. That's a long time to think about what he's doing. And, it is ambiguous, but knowing what we know and considering all the facts and circumstances of this case, what was he thinking that when he wrote that? He was probably thinking about what he was about to do. And then on the same day, true forgiveness is the answer, or we will both burn in hell. Again, that was on the 19th, 8 days before he did what he did. Then on the 18th, I'm thinking you want this to get ugly. 9 days before he did what he did. And then this, on March 12th, it's more than 20 days before he did what he did, before he killed Amy Ross. I've asked God to forgive me for what I'm about to do. Randy thought about this for a long time. The defense wants you to take a look at the text messages. Take a close look at those. And the defense, when Mr. Deck was arguing about the text messages, there was a common theme during that. And that was, think about what Randy was saying. What was Randy saying? What was Randy saying? When you look at those text messages and review them, you'll see me the entire time. It's all about what Randy wants, what Randy's thinking. There are many text messages where it's just Randy, and then eventually you'll see a response from Amy. He's bugging her. He's harassing her. He doesn't want her to leave. It's been going on like that for a long time. He was wanting to control Amy, and when he came home on the 27th and saw that she had moved out, he couldn't deal with that anymore. And he had thought about this, about what he was going to do. Look at the text message. We didn't just pull out, we did pull out some to highlight some points, but this theme is pervasive throughout all of the messages. And if you go back and you look at them, I have asked God to forgive me for what I am about to do. He had thought about what he was going to do. He knew he was going to, he would kill Amy if she left him, and she left him on the 27th. He had a lot of time to think about it. The relationship was toxic. They had a bad relationship. There's no doubt about that. That doesn't mean that when it all ends, you take a gun, you drive an hour to your soon-to-be ex-spouse's house where she's staying, you break down the door, you run up the stairs, and you shoot your soon-to-be ex-spouse in the heart. It's not what people do. It was calculated, and he meant to do what he did. He showed up at the house. He was going to break down that door if it wasn't open. He broke it down. He ran up the stairs. When they ran up the stairs, he shut the door. He grabbed Amy by the hair, and he said to her, "You're not going to take everything from me." And then he shot her. And that kind of conduct cannot be tolerated, and the defendant should be convicted on all counts of the indictment. Thank you.
Do you wish to address that further? Basis? Approach, Judge.
I'll draw the same.
All right. That statement last statement by the prosecutor is withdrawn. Move to strike?
Yes, Judge.
And stricken from the record. So it should be as if you did not hear it. During your deliberations, you must not discuss or consider the subject of punishment. The question of punishment rests entirely with me. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your findings with intelligence and impartiality, and without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will know that this case was fairly and impartially tried. If during the course of the trial the court said or did anything that you consider an indication of the court's view on the facts, you are instructed to disregard that. You, the jury alone, must decide the disputed facts in this case. Now, a copy of these instructions have been provided to you. If during deliberations you're in doubt about a portion of the instructions, you may request such information. The foreperson must put your question in writing, indicating specifically what is requested. Such communication must be delivered to the bailiff. Your initial conduct on entering the jury room is a matter of some importance. It is not wise to immediately express a determination or to insist on a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you later decide you are wrong. So instead, I would suggest that you consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a thorough discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest beliefs in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. In arriving at your verdict, you are encouraged to use your own common sense, your knowledge of human nature, and the ways of the world. At the beginning of the trial, Ms. Hayes, Ms. Balog were selected to serve as alternate jurors in the event of any misfortune to a member of the panel. You will not deliberate with the panel at this time, but you will remain separately here in the courthouse. You may still be called upon during deliberations. I must caution you that you are not to discuss this case or tell anyone how you would have voted until the jury has returned the verdict. You will remain with us. I want to thank all of you on behalf of the public and the parties for your service as alternate jurors in performing this important function. Now, after the verdict is returned, you and all members of the jury may discuss this case with anyone, but you're not required to do so. Whether you discuss this case with counsel or anyone else after your discharge and after you have returned your verdict is clearly a matter of your own free choice. We will place in your possession the exhibits and the verdict forms. The foreperson will retain possession of those records, including the verdict, and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Now, until your verdict is announced in open court, you are not to disclose to anyone the status of your deliberations or the nature of your verdict. After you retire, select a foreperson, and whenever all 12, I repeat, all 12 jurors agree on a verdict, you will sign the verdict in ink and advise the bailiff by knocking on the door of the jury room. You'll then be returned to the courtroom. Now, we will deliver those exhibits and other materials, the verdict forms, into the jury room. You will have the gun, you will have gloves for anything you wish to handle. I'm not sending the bullets in at this point. If you want to see the bullets, knock on the door and we will make arrangements to bring in those live bullets. We may remove the gun at that time. If you wish to review or re-listen to the 911 tape, which is on a disc, the only way to do that really is in the courtroom. So the process would be, if you wish to do that, knock on the door, advise the bailiff. The bailiff will operate the computer system for you so that you can listen to that call in here. You can listen to it as many times as you want, whatever parts you want. You can pause it, whatever you want to do. Now, I would ask that you not discuss the matter in here. This room is monitored by security devices at all times. So don't discuss, don't deliberate in That's only for that room. Your schedule is your own from here on out. You will stay as long as you want to stay. You'll leave when you want to leave. You'll take breaks when you want to take breaks. That's all your choice. Now, if someone wants to go out and smoke a cigarette, that's when all deliberations cease. Everyone, all 12 of you, must be present when deliberations are taking place. Do you understand that? All right. Do you have any questions at this point? You may now commence your deliberations. Thank you.
No, you can get stuff yeah.
You and Lori come out here. Sarah will direct you where to go. You want to come on out here with me just a moment? Counsel, is there anything further at this point?
No, yeah. No, yeah.
All right, thank you. Well done.
And we should, let's review, because I have some gaps.
Okay. You and Marie,
Yeah.
work at it.
There are some gaps.
Okay.
There are.
Like 30 of them maybe.
Sounds about right.
Okay.
This pictures we decided not to use.
Let me just go through and make sure we have everything. I have my evidence, I have my exhibit list.
Yes. Anyone?
Nicely done. Nicely done, Mark.
Thank you.
All right.